Penal Code 1860 is a substantive law of crimes. And it is defining the acts which are forming the offense and it lays down the punishment for the same. That's why we are calling it as a substantive law. And it lays down certain principles of criminal law and the procedural law through which the Indian Penal Code is implemented is the Criminal Procedure Code 1973. So this Criminal Procedure Code 1973 mentions about the procedures which we are going to follow in a court of law. And the basic function of the criminal law is to punish the offender and to deter the incidence of a crime in the society. So all the crimes are said to be done against the society. And the purpose of this criminal law is to punish the offender and maybe to deter the incidence of crime in the society. So first of all, before learning about the Indian Penal Code, we have to understand the fundamental elements of a crime. The first element is the human being. A human being having legislative obligation and who can be punished by law is the subject matter of criminal law. Then there is a mental element of crime called the mens rea. This mental element is based on a particular maxim called actus non facit reum nisi mens et rea. It's a Latin maxim which mentions that an act does not constitute guilt unless accompanied by a guilty mind. So mind of the wrongdoer is judged by the act. So the physical action along with the mental element is an important factor to form a crime. And there are different forms of this mens rea. And the first form is the intention of a person. What is the meaning of intention? It's nothing but the mental design to do an act. Maybe it is specific or generic in nature. And the second kind of the mens rea is the negligence. What is this negligence? The act not taking care when there is a duty to take care. And there is another factor called the recklessness, in which the actor does not desire the consequences but foresees the possibility and is consciously taking the risk. According to the traffic laws of the country, maybe there is a restriction with regard to the speed of the vehicle in which you are riding. And if you are breaking the speed and going in an overspeed, you may not desire the consequence of an accident. But having the overspeed, you can foresee the possibility and you are consciously taking the risk of an accident. This is called recklessness. And mens rea is not essential in certain cases. There are certain cases in which the mental element is not taken into consideration. In the case of social welfare and public safety, absolute liability is there. No mens rea is taken into consideration. You remember the Bhopal gas tragedy in which the companies are said that if they are causing some kind of a pollution, absolute liability is there. Just like that, in the case of crimes also, when there is social welfare and public safety is of prime importance, absolute liability is imposed. Then there are petty cases where fine only is the punishment. There can be some traffic violations. Maybe one is riding without a helmet. These are all petty cases where no mens rea is taken into consideration. And public safety is another area where there is no need of taking into consideration the mens rea of a person. And violation of a law without knowledge of its existence. And it is expressed in a maxim, ignorantia juris non excusa. Ignorance of law is not an excuse. Even corporate bodies are subjected to this law. And now comes, after the mental element and the human being, the third factor is the actus reus, called the act or omission. If a person is doing something against the law, that action is punishable. If a person is vomiting to do something which is supposed to be done by that person, that also can be regarded as a crime. When it comes to the children, they are to take care of their aged parents. If the children of the aged parents are not taking care of them, it's a crime. So act as well as omission can result in a crime. And these are the elements of a crime. Then there are the stages of a crime. Let us see what are the main stages. When a person is committing some crime voluntarily, it involves four important stages. Each and every crime is having explicit stages. There are four in number. The first stage is the criminal intention. It is nothing but doing an act with one's will, desire, voluntariness, etc. Out of your free will, you are going to do something. Forming an intention in the mind. It's normally not punishable, but in certain cases, when there is a preparation to wage war, make counterfeit coins or garment stamps, possessing the counterfeit coins, false weights, measurements, and forged documents, then preparation to commit dacoity. In these areas, intention also is punishable. So normally, forming an intention in the mind is not punishable. But when it comes to sudden offenses like we have mentioned now, the criminal intention is punishable. And after the intention, the second stage of a crime is the attempt. It's a direct move towards the commission of the crime after making necessary preparations. An attempt is punishable. Sections on attempt are divided into same sections in which attempt and commission are dealt with. There are certain sections in which attempt and commission are dealt with in the same section. Dacoity, waging war against the state, sedition, public servant attempting to accept gratification. Then there are sections where attempt is separately punishable, robbery, murder, etc. Attempt to commit suicide under section 309 IPC. So in both ways, attempt is punishable. Then comes the fourth stage called the commission of crime or accomplishment. So you are forming an intention, then attempting, then only there is a commission of the crime comes. An accused is presumed to be innocent until a crime is proved against him. And prosecution should prove beyond all the reasonable doubts. That's very important in the case of commission of a crime. Then the punishments of a crime are also mentioned under IPC. The capital punishment which is given for a criminal is the death sentence. It's the harshest of the punishments which is awarded in the rarest of rare cases. Example, murder and treason. Then there can be life imprisonment. It's a rigorous kind of a punishment. Then imprisonment, rigorous and simple imprisonment can be there. Forfeiture of the property of the person who is a criminal, putting a fine on the person. That means forfeiture of the money by way of penalty. When fine is not paid, he has to undergo default sentence. So these are the kinds of punishments when it comes to a crime. And let us see what are the crimes which are important as far as a company secretary is concerned. There is a list of crimes under the IPC, but we are not supposed to learn all the crimes under this executive course. We have certain crimes which are important as far as a company secretary is concerned. And the first one is the criminal conspiracy coming under section 120A and B. when two or more persons agree to do or cause to be done an illegal act, or an act which is not illegal but done by illegal means. So an illegal act and an act which is not illegal but done by illegal means, and there is an agreement between two or more persons regarding this act, such an agreement is designated as a criminal conspiracy. So two or more persons are very important for a criminal conspiracy, and there must be an agreement between these people to do an illegal act or do some act by illegal means. This is essential. There is a case, R. Venkatakrishnan versus CBI, in which it is told that there must be direct evidence and circumstantial evidence to prove that there was an agreement to commit crime. And another famous case is the Parliament attack case, NCT of Delhi versus Navjot Sidhu, and in which punishment of criminal conspiracy is mentioned. The agreement between the people we have to prove before proving a criminal conspiracy. And in serious offences, punishment is given as if a party to conspiracy abetted in the offences. So abetment is a crime under IPC. Abetting means helping the other person to commit a crime. And the abettors are the criminals. Other offences, the punishment is lesser. And the second crime which we have to learn is the criminal misappropriation of property. And it is falling under sections 403 and 404 under the IPC. It is dishonestly misappropriates or makes use of a movable property as his own. So the subject matter is a movable property. When someone is misappropriating or making use of a property as his own, and that he is doing with a dishonest intention, it is called the criminal misappropriation of property. And it is punishable with 2 years of imprisonment or fine or both. Dishonestly means anyone causing wrongful gain to one's person and wrongful loss to the another person. So you are using the property of a person dishonestly. It means that you are using the property as your own to make a wrongful loss to the other person, and you are getting a wrongful gain out of it. So these are the factors which we have to prove in a criminal misappropriation of property. Now let us see what is meant by a misappropriation. It's nothing but intentional illegal use of the properties or funds of another person to one's own use or other unauthorized purposes. Next crime is the criminal breach of trust. In this, accused entrusted with property or with any dominion over the property, that means accused having the control of the property, uses that property. Accused dishonestly use or dispose of that property. Under criminal breach of trust, accused is entrusted with some kind of a property and he is breaking the trust of the owner. The best example is in the case of a will procedure, and if someone is not proceeding the provisions of the will as directed by the person. So whoever is writing a will or whoever is forming a will intends that after his death, his will should come into existence and some person is appointed to execute the will. And if that person is not proceeding with the will as directed, it is nothing but criminal breach of trust. He is breaking the trust even though that person is dead. Then ingredients of this criminal breach of trust. When it comes to criminal breach of trust, there is a fiduciary relationship between the accused and the person who entrusted property to accused. Accused could control the property, and the property can be movable or immovable. In the case of misappropriation, we have seen that it must be movable property. But under criminal breach of trust, the property can be movable or immovable. And dishonest intention to misappropriate is a crucial fact which is to be proved in the case of criminal breach of trust. There is a famous case, Pratibha Rani versus Suraj Kumar, in which dishonest intention to misappropriate is a criminal fact is to be proved, is mentioned. The in-laws of Pratibha Rani having the custody of the gold ornaments of this lady. And it was told that they misappropriated the property with a dishonest intention. And dishonest misappropriation of property possessed by a deceased person at the time of his death. That is falling under section 404. In such kind of an offense, the imprisonment is for 3 years. And 7 years in the case of a person who worked as a clerk or servant of the deceased person at the time of his death. So at the time of the death of a person, if you are misappropriating property, the punishment is only 3 years. But if you worked as a clerk or servant of the deceased person, the level of punishment will be 7 years. That time, the factor of trust is taken into consideration to punish the person. Next offense is cheating. It is nothing but deception of any person, and there is an inducement caused by deception. Non-disclosure of the relevant information also includes deception. That means if you are not disclosing what is to be disclosed, your silence also can amount to cheating. By your action, you are deceiving the other person and you are inducing him to do something. And there can be cheating by personation. What is this? In which a person pretends to be another and he is doing it knowingly. He is substituting one person for another in the case of cheating by personation. And the punishment for cheating by personation is 1 year imprisonment or fine. When a person knowingly cheats another to cause a loss, imprisonment for 3 years or fine or both. Then there are frauds connected with the insolvency. Dishonest disposition of property with an intention to cause wrongful loss to the creditors. It may apply to movable or immovable property. Dishonestly or fraudulently prevents the defending of creditors by masking the property. Then comes forgery under sections 463 and 465. What is this forgery? The making of a false document or a false electronic record or part of a document of electronic record to commit some kind of a fraud. So forgery also is falling under a fraud. It's making changes in the document. Maybe it can be an electronic record also. Totally you are changing or a part of it you are changing. Both coming under the forgery. And for forgery, the punishment is 2 years imprisonment or fine or both. Now comes the offense of defamation, falling under section 499 of IPC. Defamation is a statement made in permanent and visible form to defame a person. It can be in the form of libel or slander. When there are spoken words used to defame a person, it's called a slander. When it is written, you call it as libel. Even the dead can be defamed. When you are affecting the reputation of a dead person, his family is affected. So that is also falling under the offense of defamation under section 499. You can ironically defame also. No need that you directly attack the reputation of a person. Ironically also you can defame. That is also falling under the offense. And it lowers the status of a person by affecting his reputation in the society. Then there are certain exceptions which are coming for this offense of defamation. The first exception is the imputation of truth which public good requires to be made or published. Certain truths for the public good we have to publish. So welfare of the public is something very important even for our governments. So in public interest, certain truths can be told. Then the public conduct of the public servants, even though it is affecting some people, it is public conduct done publicly. It's a part of the action of the public servants while serving the public. That's an exception. Then the conduct of any person touching any public question in good faith. So good faith is important. With a good intention, if you are answering any public question, that is exempted. Then the true reports of the proceedings of a court, what is happening inside a court, if you are reporting truly, it's exempted. Then report of the cases which are decided in a court, maybe about the conduct of witnesses and others concerned in good faith. Reports on merits of public performance of people. Censure passed in good faith by person having lawful authority over another. Accusation preferred in good faith to the authorized person. Imputation made in good faith by for protection of his or others' interest or for public good. So this public good or public welfare is something which is always important. Even it is falling under the category of the exceptions to the defamation. Caution intended for good of person to whom conveyed or for public good. And for defamation, the imprisonment is 2 years or fine. And that punishment is falling under section 500. And a person printing or engraving a defamatory matter abets the offense. It's like helping the person to commit a crime. Once you are printing a defamatory matter, it's like you are helping, assisting, and it's an offense falling under section 501. Sale of the printed or engraved substance containing defamatory matter also is a crime under section 502. So all these sections are connected from 499 to 502. Now there are certain general exceptions which are mentioned under IPC. And the general exceptions are coming under section 76 to 106 of IPC. So we have listed out crimes like defamation, misappropriation of property, cheating, breach of trust, etc. Now comes the general exceptions to the crimes under the IPC. The Indian Penal Code 1860 provides general exceptions for a person accused of committing any offense under the code to plead in his defense. Absence of mens rea or guilty mind. 6 categories of exceptions are there. There are judicial acts, mistake of the facts, accidents, tripling acts, consent of the person, then absence of the criminal intention. First of all, let us consider the mistake of fact. Fact means something which is existing. It is daytime now. If you mention during a daytime, it's a fact. And it also implies that it is not a night now. And this mistake of fact is based on the maxim, ignorantia juris non excusat. Ignorance of law is not excused, but when there is a mistake of fact, it is excused. The act of a judge when he is acting judicially, an act done in pursuance of a judgment or order of a court. As per the order of the court, you can even execute a death sentence because it is in pursuance of a judgment. It's not a crime that you are killing a person at that time. Such an order to kill the person you have obtained from a court of law. Some death sentence is executed against a person as per the judgment of a court. Then it's not a crime. It's an exemption. Then mistake of facts justified by law. Sudden facts are justified by law. If an advocate is causing some kind of a mistake, and that can be referred as a mistake of fact, and it is exempted. Accidents in doing a lawful act. If you take an example from the arena of sports, injury in sports and games, it's caused because of some kind of an accident. Then acts likely to cause harm but done without criminal intent and to prevent other harms. Two people are there fighting in between. So, to remove a person from that scene, you can adopt some measures like harming that person. It is justified. Otherwise, some murder may take place in that area. Act of a child under 7 years of age, children are missing in judgment. So, children below 7 years of age are exempted. In the case of a child between 7 and 12 years of age, that is also exempted when the child is of immature understanding. Below 7 years, anyway, it is exempted. Between 7 to 12 years, it is checked by the court whether the child is having immature understanding. Then it is exempted. An act of a person of unsound mind. Act of a person incapable of judgment by reason of intoxication caused against his will. So someone is forcefully intoxicating a person with liquor and making him do something based on that intoxication. Such an affair is exempted. Then acts based on volunty non-fit injuria. What is this maxim says? He who consents to an act does it himself. Once you are consenting to some act, later on you cannot blame. An act not intended to cause death done by consent in good faith for person's benefit. Surgeons are doing surgeries and that surgery is done with the consent of the person. Even though death is caused, the justification is that the surgery had been done to prevent the death, to make the person come to life. But unfortunately, death has happened. Surgeon is doing it in good faith to save a person from death, and that is exempted. Then act done on consent of guardian if done in good faith for the benefit of a minor or an unsound person. In the case of minors and unsound persons, they don't have the power of judgment. Because of that, a guardian is appointed for them. And when a guardian is giving his consent in good faith regarding some matter related to the minor or an unsound person, and some mishappening is there, it is excused. Then consent is a relevant factor when it comes to exemption. Exclusion of the acts which are offense independently of the harm caused. An act done in good faith for benefit of a person without consent. Communication made in good faith. Example, surgeon telling a patient of his chance to die. Suppose a person is having liver cirrhosis and he is suffering because he's a chain smoker. In such cases, the surgeon will tell the dangers of smoking to that person, and maybe the surgeon has to tell that he will die if he is continuing with his smoking. And if that person dies, surgeon is not responsible because it's a part of his profession. He has done that communication in good faith to save the person. An act to which a person is compelled by threats of another. You are threatening someone to do something. He is not responsible because he has done that out of the threat made by you. Then acts causing slight harm. So these are all the general exceptions